Committee members, bon matin à tous. We will begin again. The clerk has advised me that we have a quorum. Everybody is appearing. Everybody is appearing in the committee room. So we did not require any sound testing. Again, I would remind you before we began about the steps that have been advised that committee must take to avoid sound issues for the translators. Please keep your earpiece in the allotted spot while we're doing, when you're not using it, and if you're not going to use it at all, it is best to keep it unplugged. And as you know, the room layouts have been adjusted to give more spacing to avoid any possible sound issues. And again, keep your earpiece turned down or on the allotted allocation. Today's meeting is taking place pursuant to Standing Order 1082 and the motion adopted by the committee on February 27, 2024. The committee is beginning its clause-by-clause consideration of Bill C-58, an act to amend the Canada Labour Code and the Canada Industrial Relations Board regulations. Before I introduce departmental officials, I would advise members you have the choice to speak in the official language of your choice. If translation services are interrupted, please get my attention by raising your hand. We'll suspend while they are being clarified. So today, appearing in the committee room from the Department of Employment Social Development, Madame Zia Prue, Director General, Strategic Policy Analyst and Workforce. Catherine Chan, Senior Policy Analyst, Workplace and Labor Relations Policy Division. Mr. Ryan Cowling, Manager, Workplace and Labor Relations Policy Division. They're here to address any questions any committee members may have as it relates to the clause-by-clause of the bill. So with that, again, thank you, members. And yeah, I do apologize. Somebody forgot to order the breakfast, or we didn't pay for the last one, and we're not getting any more. It will get corrected. Ms. Gray has agreed to pay for it if we can't find the funds. Okay. On a serious note, this is a serious piece of legislation, so I will begin going through, as you are all familiar with the process, with clause by clause. If you have any comments, please raise your hand. So we shall begin with clause 1 of the bill. There was no amendments submitted, so shall clause 1 carry? See an agreement? Clause 1 is carried. Shall clause 2 carry? See no discussion. Clause 2 shall carry. Shall clause 3 carry? Discussion? See nodding. Clause 3 is carried. Shall clause 4 carry? You're going to have to tell me what no's are. Seeing no discussion, clause 4 is carried. Shall clause 5 carry? Seeing no discussion, clause 5 is carried. Now with clause 6, the first amendment is from the NDP. Mr. Bulleris, you wish to speak to your amendment?
Oui, merci beaucoup, Monsieur le Président. Ça me fait extrêmement plaisir d'être ici avec vous aujourd'hui pour cette étude importante de ce projet de loi qu'on peut qualifier d'historique, là, qui a été...
Ah, excuse.
I'm very happy to be here tomorrow.
Un moment.
Tout est beau maintenant.
How did we lose?
The English channel is now working.
Okay.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I hope interpretation is working now, and I hope that everyone can hear me. Excellent. So with regard to the 90-day wait time for the Canada Industrial Relations Board, many witnesses told us to shorten that to 45 days. That's what this amendment is regarding, to reduce the 90 days for rendering a decision. That's it. Thank you.
Mr. Sheen.
I just wanted to point out that I have a sub-amendment, and Chair, if you wanted to point out when it would be appropriate for me to move that. Sub-amendment to the amendment.
Deal with the. Yep. Okay, we have the amendment of Mr. Bolarus on the floor under debate, and we have a sub-amendment to that amendment. Mr. Sheen. Mr. Sheen, then we'll go to Mr. Seaback and then Madame Chabot.
Well, thank you very much, Chair. And
Remember.
Yeah, I didn't hear that. Répétez, Madame.
Could you please repeat?
Levez ma main.
I had raised my hand. Oh.
Ça que...
Yes, I got it.
Désolé, Monsieur le Président.
Sorry, Mr. Chair, you did say my name. I haven't had enough caffeine this morning.
Bon. Mr. Sheehan?
well, thank you very much. On the sub-amendment, we had originally chose 90 days to ensure that this process did not infringe on the right to strike. And most of the time, it takes more than 90 days to be in a strike position. During committee, we heard from unions that the due maintenance of activities process could delay their right to strike. We listened and we did the math. And in good faith, we're proposing a sub-amendment to reduce the CIRB's decision-making timeline to 82 days. That's why we're bringing forward a sub-amendment to reduce the CRB decision-making time on maintenance of activities issues to no less than 82 days. That really is the shortest possible time we could see a union get to the strike position. Therefore, it will not delay a union's right to strike. With this change, unions who respect the timelines laid out in the bill will not see their right to strike delayed in a single day, even if the CRB takes the full 82 days to make a decision. And just further, we heard in testimony too, it was 155 currently. We were proposing 90. We're proposing 82 after extensive dialogue to make sure that the CRB can get the job done. So, merci.
Mr. Sheehan. So now discussion moves to the sub-amendment of Mr. Sheehan. Mr. Seaback.
He explained it, so I don't have a. I was going to ask the analysts. I don't need to now.
Okay. Madame Chabot on the sub-amendment. Madame? Oui.
Is it my turn? All right. Thank you, Chair. Your arguments are logical. We've all heard unions. I could name many unions: CSM, metal workers, the Canada Public Service Union. They were overwhelmingly in favor of shortening the wait time from 90 days to 45 days. That is what they're calling for, so that their right to strike is maintained in a reasonable time frame. So I'm against your sub-amendment which does not take into account the calls made by unions before us. It would only change the wait time by 8 days, from 90 days to 82 days. I think that if there is true will to uphold the workers' right to strike, then in that case, 90 days is unreasonably long, and 82 days would be just as unreasonably long, which is why I'm inclined to disagree with the sub-amendment. I do support the NDP's amendment. The NDP amendment is similar to the Bloc Québécois amendment, BQ1.
Okay, seeing any further discussion on this sub-amendment, Mr. Sheehan?
I just wanted to point out that we, again, in testimony and a lot of the questions that were being asked to the particular board by various committee members, they had stressed the need for more time, more resources, and we're committed to getting resources to them. 82 will put them in a position as this rolls out to be able to deal with this expeditiously and to keep everything in accordance. So, thank you.
Okay, seeing no further discussion, I'm going to call for a vote, recorded vote on the sub-amendment as proposed by Mr. Sheehan to the NDP amendment. Clear? Madam Clerk?
Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Non.
Monsieur Boulris?
Oui.
Yeas pour, 10, nays contre 1.
The sub-amendment of Mr. Sheehan to NDP 1 has been carried. We will go back to NDP amendment as now amended. Any further discussion? But before I go, if the committee decision on NDP 1 amendment as amended, if it's carried, then the amendment from Madame Chabot is non-debatable. Okay, so seeing no discussion, then I'm going to call a recorded vote on the amendment submitted by Mr. Bolarus that has now been amended by Mr. Sheehan. So we're clear, Madam Clerk. We're voting on NDP 1 as amended.
Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Monsieur Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gray? Yes. Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Non.
Monsieur Boulris?
Oui.
Yeas pour, 10, 10, nays contre 1.
NDP 1 is carried as amended. That means the Madame Chabot's amendment can no longer be moved because it is identical. Now, shall Clause 6 carry as amended? Seeing a consensus, so Clause 6 is carried as amended. Shall Clause 7 carry? Mr. Sheehan on Clause 7?
I just wanted to drop down the clause. I believe you have it. And it's the Bill C-58 in Clause 7, be amended by replacing line 17 and 18 on page 4 with the following, reference to any other person. And, unions raised an issue that there were, in certain cases, replacements were brought in for emergency situations, might not be captured under the reinstatement provisions. So this amendment resolves that issue, and I understand the intent of NDP 9 was to fix the same issue. This will make the amendment unnecessary, that we were just providing some needed clarification after consulting with the various folks.
Okay, we have a amendment moved by Mr. Sheehan. Mr. Seaback?
I think it's really unfortunate that the government that has all the resources available to it decides to drop a series of amendments the day we're going through clause by clause, which gives us absolutely no time to go through and determine what the effect of these will be. We all had lots of time to prepare for the NDP and the block amendments, who professionally put those amendments in on time. Do any of the witnesses today, can they comment on what the effect of this amendment will actually do with this insertion in that clause?
I'll turn to my colleague, Ryan Cowling, who can explain the impact of this amendment.
Sure. I think my microphone is on. With this amendment, it would be a broadening of the reinstatement provision found at Clause 7. So that would amend 87.6 of the code, and what it would essentially provide now, as amended, is that when striking or locked out workers return to their job after the strike or lockout ends, they have preferential reinstatement over any other person who may have been performing any kind of work for the employer during the strike or lockout. As 87.6 had been written, there was a small chance that if the employer brought in new employees during a strike or lockout under those exception conditions that we have in the bill at Section 94 sub 7, then that they wouldn't be captured by that reinstatement, and thus returning workers wouldn't necessarily be given preferential treatment over them. So this would be broader and capture those people as well, as the change that this would make.
These people possibly be? Like, I'm finding it hard to understand what the distinction is between any person and any other person.
My understanding of the amendment is that it's removing the words whose services were used contrary to subsection 94.4. And so what it's doing is getting rid of that caveat and making it about any person.
Well, no, it says any person now, right? 87.6 says, at the end of a strike or a lockout not prohibited by this part, the employer must reinstate employees in the bargaining unit who were on strike or locked out in preference to any person whose services were used contrary to subsection 94 sub 4. But what's actually being added in preference to any other person whose services were used contrary to subsection 94.4. That's how I understand this amendment.
So this
And so I don't know what the difference between any person and any other person. That's what I'm trying to understand.
So this may be a question for the legislative clerk, but my understanding of the amendment is that they're getting that this amendment would remove the words whose services were used contrary to subsection 94.4, and thus it's now no longer saying that in order for an employee returning from a strike or lockout to replace someone, they have to have been used illegally in the context of that strike. So now it's saying even if the employer relied on the exception and brought in someone to do that work that's outlined in the bill at 94.7, like threat of immediate or serious, threat to life, or health, or safety, or damage to property. If an employer used that exception and brought in another employee under that condition, then as it's currently written, we believe that the reinstatement provision as written wouldn't necessarily give a returning striking or lockout employee the ability to replace that person. So this change, making it any other person, gets rid of that distinction. It doesn't have to be an illegal use of replacement workers. It's just any person who's used. So I hope that's helpful. I know I'm talking a lot.
So it's deleting whose services were used contrary to subsection 94.4 and replacing any person with any other person. Okay.
Mr. Seebeck, I have Madame Chabot, but I'll come back to you if you have a question. Madame Chabot?
Avec respect,
Well, with all due respect, I don't see how that improves or strengthens the clause. The motion you're moving seeks to remove whose services were used in breach of another article. So I don't see how that's an improvement. And you refer to any other person. Well, what is your definition of other? That can be interpreted in a number of ways. But in this case, the text of the bill says 87.6 because that's what would be amended. The text of the bill says it preferably to all those whose services were used in breach of the bill. So that's what the preference would be. 94.4 to 8. It bans replacement workers. So I don't see how your motion would improve things. I don't understand the intention of the motion. And you say that it's similar to an NDP motion. Well, which one?
Sheehan,
Just
on
wanted to
your amendment.
Just wanted to make sure that I explained it the way that the intention is by providing this other statement. This amendment allows and gives preference to the striking or locked out employees, so they must be reinstated in preference to any other person at the end of the strike or lockout. So, hypothetical situation, some company somewhere has an emergency situation and they bring in some employees that are doing the work. They're there now whilst the strike is happening. So at the end of the strike, those people that are doing that work for whatever emergency reason that they're there, that person would not be, replacing the job of somebody in the bargaining unit that was on strike. Am I correct, Mr. Cowling?
Yeah, I'd say that's a fair characterization of it.
Okay, thank you.
Okay, we're going, excuse me, to Mr. Seaback, Mr. Bulleris, and then Ms. Gray. And I would remind members, please direct your questions through I, the chair. Yeah, Mr. Seaback.
So, Mr. Chair, I'm just wondering, what's the effect of taking out whose services were used contrary to subsection 94 sub 4? Because that's what's being, that's the other part of this, right? We're putting other persons as opposed to persons, and then we're taking out whose services were used contrary to subsection 94 sub 4.
Sure.
Please, who's responding to Mr. Seaback? Who's responding? You, go ahead.
Oh, yeah. Yeah, unless anyone else wants to take it. Maybe the best way to explain in a clear way, which unfortunately I haven't done up to this point, so sorry about that. But the words where it says contrary to subsection 94.4, it's saying that the people that returning striking or locked out employees have the right to replace are people who were used illegally. The issue is if you look at 97 or the proposed 94 sub 7, which is the exception, threat, destruction, or damage, it says at the top that an employer does not contravene that ban if they hire people to do work in these emergency situations during a strike or lockout. So right now, if that were to happen, if the employer during a strike or lockout were to bring in someone to respond to a threat to the life, health, or safety of any person or destruction of property, then as written currently, the returning striking or locked out members wouldn't necessarily have a right to be reinstated above those people because those people weren't hired illegally. They were hired within the four corners of the law. And so this represents an expansion of the right to reinstatement, so it also includes those people if they were brought in during the strike or lockout. So it basically gives the union members a right to return in preference to anyone, whether illegal or not, that was doing their job while they were on strike.
Okay, Mr. Bulleris and then Ms. Gray on the amendment.
Thank you, Chair. I wish to reiterate my interpretation and my vision. It's a bit like Mr. Frawling said, there are exceptions to the use of replacement workers when the health, safety, and security of the public is at risk, for example, if there's an environmental risk. So that is a legal lawful use of replacement workers. Many unions told us that they were worried, in fact, that some workers are not prioritized when it comes time to return to work. So we need to address that situation. And that was brought up by the Metal Workers Union, other unions. The members of the accreditation unit need to be prioritized, even above replacement workers who are lawfully used to protect the health and safety of the public.
Thank you, Mr. Bullers. Ms. Gray?
Thank you, Mr. Chair, and through you. Obviously, we have some questions because the Liberals didn't meet the deadline in order to get amendments in, and here we are trying to analyze this on the fly here. But the question that I have for the witnesses through you, Mr. Chair, this was touched on briefly, but I just want to I just would like some further clarification on how this might affect workers that come in during an emergency. I think there was a little bit of mention to it, so I'm wondering if you can just speak to that.
So this provision is specifically just about the right of employees returning from a strike or lockout to be reinstated to their jobs. Okay. And so what the amendment does is broaden who they have a right to reinstatement over, essentially, if that helps. So when under the way that it's written currently, if an employer were to bring in a new employee in an emergency situation as enumerated in 94.7, then that person, then the returning striking or locked out workers wouldn't necessarily have a right to be reinstated over that person because that person wasn't used illegally. So what this amendment would do is say, regardless of whether it was illegal or not, if someone was brought in to do the work of striking or a locked out worker during the course of the strike or lockout, then the returning workers have a right to be reinstated over those people.
Okay, seeing no further discussion, I'm going to call a vote on the amendment to Clause 7 of Mr. Sheehan. Madam Clerk?
Mr. Farkas-Gatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gregg?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yep.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Okay, the amendment of Mr. Sheen was carried unanimously. Shall Clause 7 carry as now amended? Seeing no discussion, Clause 7 is carried as amended. Shall Clause 8 carry? Discussion? Seeing none, Clause 8 is carried. Clause 9. Clause 9, we have an amendment from the NDP, NDP 2. And if it's adopted, NDP 3 and Bloc Québécois 2 cannot be moved due to a line conflict. Mr. Bullers, on your amendment.
Merci beaucoup, Monsieur le Président. C'est un
Thank you very much, Chair. This is a very popular section for amendments, so of course we're going to have a lot of work to do on this section. Now, our amendment number 2 reflects the concerns brought forward by many witnesses about the use of subcontractors in the case of a strike or labor conflict. They brought up the fact that it's difficult to determine whether the use of replacement workers is excessive or whether they're used as a way to put pressure on unions and members of bargaining units. Hiring subcontractors before the notice to bargain can put significant pressure on the employer, a financial pressure to pay these replacement workers for a while. But many unions raise the risk that an employer with significant financial means can, ahead of time, find a bunch of replacement workers who can then do the work of the members of the bargaining unit who are striking or on lockout. So this would address that concern raised by unions. That is why we're moving this amendment, NDP 2, so that subcontractors cannot continue their work throughout the duration of the labor conflict. So that is the gist of NDP 2. Thank you.
And then Madame Shabat on NDP 2.
Thank you, Chair. And in the Canada Labour Code, the definition of employee already captures dependent contractors. And a dependent contractor are contractors that are that rely solely on one employer or contract. Dependent contractors occupy the same labor market space as employees, so they are eligible for unionization. These folks, are potentially part of the bargaining unit and paying dues. They're, a member of local XXX, and they pay the dues, so they just occupy the same space. So I would turn to our officials, through you, Chair, to perhaps explain what I was saying about how the Canada Labour Code already captures dependent contractors and what dependent contractors are as opposed to other folks.
Thank you, Mr. Chair. I just wanted to start by making a clarification before I turn it to Ryan Cowling for an explanation between there's a dependent contractors and independent contractors. So there's a distinction in the code, and I know we wanted to get into the amendments, but I just wanted to clarify, Monsieur Boulris, je sais que vous connaissez la distinction, mais peut-être pour...
I know that you're aware of the distinction, but I'll just remind everyone around the table, as it stands, the bill distinguishes between the two, so it will be clarified in the code. But it really is just to clarify that contractors may continue their work if they were hired before the notice to bargain. If they were already working before the notice to bargain, they can continue the work that they were doing in the same manner. So if they were working 3 days a week before, then, and we're not talking about strike breakers here, we're talking about those who are on lockout. So these individuals will do the same work they were doing before the notice to bargain. If it was 3 days a week, then it will remain 3 days a week. That is what the bill suggests, and it serves as a clarification. And now Ryan will explain the difference between dependent contractors and independent contractors, because there's a difference there. It's a terminology difference, and it is important to explain the difference between these two terms in the bill, because it relates to the amendments being moved. Thank you.
I'll try to state it as clearly as possible, but it can get a little esoteric within the industrial relations framework. But essentially, a dependent contractor is a person who's not in an like a direct employment relationship with an employer. They don't have a contract of employer. What they have is a dependence on the employer, both economically and in terms of their working conditions, that make them so similar to employees that that Part 1 of the Canada Labour Code treats them as employees. Under Part 1, the definition of employee explicitly says it includes dependent contractors. So anytime the Canada Labour Code, well, Part 1 of the Canada Labour Code refers to employees, it's also referring to dependent contractors. And similarly in Bill C-58, where you see the word employee appear, such as in the ban on replacement workers at subsection 94.4, as well as the ban on union members, employees in the bargaining unit crossing the picket line and performing work during a full strike or lockout at 94 sub 6. That would also include dependent contractors that are in the bargaining unit. So I hope that clarifies. But
thank you, Madame Shabat.
Merci, Monsieur le Président.
Thank you, Chair. I understand that we have to vote on amendments in a certain order. That's based on House of Commons rules and procedure. I support the spirit of the NDP amendment. I support its intentions. I think that we could perhaps make it clearer and more direct. We could do so by removing all references to dependent contractors. That's why, Mr. Chair, I would like to move a sub-amendment. Let us remember that in Part 1 of the Canada Labour Code, in the definitions section, there are two important definitions. First, the definition of employee. What is an employee? An employee is someone who works for an employer. Then there is also a definition of dependent contractor, meaning a person who is employee or not through a contract or services for another. What unions told us in that regard was very clear. For instance, here is what the steelworkers said. They said that employers could continue to use the services of workers during strike or lockout by calling them a dependent worker, but that would fly in the face of the goals of the bill. It could also lead to conflicts where employers would use up their resources to argue whether the employee is an employer or a dependent employee, rather than actually prioritizing resolving the labor conflict. So here's my sub-amendment. I would delete the following words in the motion after especially and until lockout. So it would be any contractor or any employee of another employer. So that would remove the notion of a dependent contractor. So it would say any contractor or any employee of another employer. And that matches the spirit of the bill, which seeks to prevent replacement workers rather than to have including and just in case and maybe, rather than having exceptions and all sorts of things open for interpretation. So that is the aim of my sub-amendment, and you will have received a copy. Thank you.
But before we go to Mr. Sheehan, let me be real clear. We're doing clause by clause today. Amendments and sub-amendments are in order to be introduced. The legislative clerk has advised me that the sub-amendment of Madame Chabot is in order and is currently on the floor for discussion. Mr. Sheehan?
Speaking to the sub-amendment, I'm going to reference the amendment too as well in the sense that, the bill is currently written, makes the clarification to ensure that dependent contractors are treated as employees, since that is how they are defined in the code. So we can't support the amendment or the sub-amendment because we don't think it's necessary, because it could lead to an inconsistency with how dependent contractors are treated under all other provisions of Part 1 of the code, Chair. So I would point to, Ryan, to see if he agrees with that statement about, as the bill currently being written, makes this clarification to ensure that dependent contractors are treated as employees, since it's how they're defined in the code. So I would ask for some comments on the sub-amendment.
Sorry, it turned on automatically for me last time. I can tell you what the bill does as currently written, with the words dependent contractor in there. And what that is essentially it's there to clarify to the reader that we're using an undefined term at the beginning of at the beginning of paragraph B there, which is contractor. And so if you were reading the code as a person wanting to apply the law, you might think that the word contractor includes a dependent contractor. But as I mentioned earlier, under the definitions of the code, dependent contractors are explicitly employees. So that the rationale for having the word other than dependent contractor there is just to avoid confusing the reader as to whether these provisions are treating dependent contractors as contractors or as employees. And to be consistent with the rest of Part 1 of the Canada Labour Code, they should be treated as employees. And so this was just to say, we've used the word contractor, but just to be clear, that does not include dependent contractors because they're under employees. So that's the intent of that.
Thank you, Mr. Cowling. Seeing the current discussion is on the sub-amendment of Madame Chabot. Seeing no further discussion, I'll call for a recorded vote on the sub-amendment of Madame Chabot.
Mr.
Yep. Go ahead.
Mr. Fergus-Cados?
No.
Mr. Long?
No.
Mr. Collins? Mr. Sheehan? Mr. Van Bynen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Ms. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yeas pour 2, nays contre 9.
The sub-amendment has been defeated. We return to the amendment of Monsieur Boulris. Any further discussion on NDP 2, the amendment of Mr. Boulris? Seeing none, I'll call for the vote on the amendment of Monsieur Boulris. Madam Clerk?
Mr. Fergus-Cados?
This is no. No.
Mr. Long?
No.
Mr. Collins?
No.
Mr. Sheehan? Mr. Van Bynen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Ms. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Ben oui.
Yeas pour 2, nays contre 9.
NDP Amendment 2 on Clause 9 has been defeated. We'll now move to NDP Amendment 3. Mr. Boulris?
Merci beaucoup, Monsieur le Président. C'est
Thank you very much, Chair. It's literally an amendment to add a comma. I never thought that I'd be here in a parliamentary committee asking to add a comma, but this is a request from union organizations to avoid certain possible future interpretations of this section. So they asked for this comma, and that's that.
Any discussion on NDP 3? I was wondering what reaction I get. Okay, then I'm going to call. Oh yeah, okay. Well, now the comma is going to displace Madame Chabot's number 2. Just as you know. So do we, Madam Clerk, a recorded vote on NDP 3, which, if it is adopted, Bloc Québécois Amendment 2 cannot be moved. Support.
Mr. Fergus-Cados?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Monsieur Sheehan?
Yep.
Mr. Van Bynen?
Yes.
Mrs. Gray? Yes. Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Oui.
Monsieur Boulris?
So
Oui.
just NDP.
Yeas pour 11, nays contre 0, aucun.
Bloc Québécois. So we go to NDP. Madame Chabot, you have your hand up?
Oui, je vais avoir besoin de...
Yes. I spoke with the legal clerk before, and he told me what to do. I'm not sure I fully remember, but if I understand properly, this disposes of my amendment, BQ2, because we have just fixed B, but I would like to bring back C from BQ2. So how do I go about that? I understand that this disposes with BQ2 as for B, but I would like to, in fact, move a formal amendment by adding, after line 4 on page 5, the following: C, any employee. This is in BQ2.
I will ask the legislative clerk to speak to what I'm advised is an accepted procedure to get it to the floor for the committee to then decide.
Thank you, Mr. Chair.
Counsel. Yeah.
So, Madame Chabot a proposé son amendement.
Ms. Chabot will move her amendment by withdrawing Part A, so BQ2 will only have Part B.
Questions, if there's any ambiguity on the procedure that I'm going to get you to consider. Mr. Seebeck.
So I don't know what we're left with. What are we actually? What is the actual NDP BQ now doing?
I'll ask the legislative clerk to speak to it, and members, any questions, simply direct them here. I don't want anybody confused.
Thank you. Thank you, Mr. Chair. So NDP 3 was adopted. So NDP 3 is behind us. Now BQ2, Madame Chabot is just moving the amendment in a new form by simply keeping the paragraph B that says by adding after line 4 on page 5 the following: C, any employee. That's all that's left.
So it's adding that onto line 4. So line 4 would read any employee of another employer.
No, it's after line 4.
So it would go after that. So it's going to go any employee of another employee, comma, any employee. Is this what we're left with?
No, it's on page 5, line 4.
Yes.
There is, you can read, or any employee or another employer.
Yes.
It's added just after that as a new C, any employee.
Oh, as a new sub C,
That's
any
right.
employee.
That's right.
Any, okay.
Yep. Make sure. Any questions, please? Yeah.
Could we have our witnesses explain what the effect of this is?
Adding a subsec, or I guess it's paragraph C, sorry, to 94 sub 4. So what it would do would broaden the scope of the prohibition on replacement workers under the bill. Currently under Bill C-50, currently under Bill C-58. Wow. The employers are only prohibited from using their employees if they were hired after notice to bargain was given in the particular dispute that's in question. And so what this would do, by my reading, is just remove that caveat and say an employee or an employer cannot use any employee to do the work of striking or locked out bargaining unit members.
I'll go to Mr. Sheehan. If you have something, Mr. Seebeck, just put my attention.
Well, thank you very much. And Mr. Seebeck had asked the question that I was going to ask. So that would cover everything, such as a manager, any employee. So a manager that would be covered under this amendment or whoever. Is that correct?
No, the managers would be distinct from the employees. So it's two categories in the proposed A. So it says, let me just get the actual text here so I'm not speaking out of turn. So the way A 94.4A is structured, it says any employee or any person who performs management functions, and that's the category that's manager. So this would just be anyone who's in an employment relationship, not including the managers.
Okay, because I was trying to, you know, in going at this, we did the tri-party approach, and, you know, we talked with everyone, and, you know, I think that I would still have trepidation with this, because I don't know what the unintended consequences would be with this, in particular, with this amendment off the floor. So we can't be supporting this right now. I think as written, it adequately, this is historic legislation which is going to benefit workers, and, you know, it's going to keep people at the bargaining table. So I'm not going to be supporting this particular amendment.
Thank you, Mr. Shane. Just before I go to Madame Chabot, so we're clear here, Madame Chabot's amendments in an order.
Ben, je
Madame
dirais que...
Chabot,
Merci, Monsieur le
un moment.
Président.
Madame Chabot.
Just a moment. Ms. Chabot, just a moment.
We moved it to a new format before it was debated, so that's why it's perfectly in order and it's left to the committee to decide. So, Madame Chabot, on your amendment. Were you speaking on your amendment, Madame Chabot?
Oui. Ben, je dirais que...
Of course. It was already included. With all due respect, this is not last minute. This was part of the amendment that I submitted yesterday. The bill, as it stands, well, I, of course, acknowledge that it's historic. It's historic to finally have anti-scab legislation federally after so long. But there is a loophole in this federal legislation which does not exist in Quebec. Here's the loophole. It would be possible to use workers from another bargaining unit of the same employer, and that is not allowed in Quebec under our version of this legislation. So adding the words any employee would fix this loophole. So in Quebec, other workers can work, for example, managers or supporting staff. But if we add any employee, then it will not be possible to use employees of the same bargaining unit of the employer. But that would be allowed with the current wording of C-58. Thank you.
No further discussion. I will go to a recorded vote on the amendment of Madame Chabot. Clear? Clear? Madame Clerk.
Mr. Fragiscados?
No.
Mr. Long?
No.
Mr. Collins? Mr. Sheehan?
No.
Mr. Van Bynen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Ms. Ferrari?
No.
Mr. HSN?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yeas pour 2, nays contre 9.
The amendment of Madame Chabot has been defeated. We'll move to NDP 4. Mr. Bulleris, do you wish to speak to?
Oui, merci beaucoup, Monsieur le Président.
Yes, thank you very much, Chair. Now I'd like to remind you about NDP 4. It reflects concerns raised by many unions about categories of workers who can or cannot go to the place of work during a labor dispute, strike, or lockout. We are adding elements C and D to include more types of individuals who would not be able to cross the picket line or go to the workplace to do certain tasks. That is the goal of this addition. Any employee who is not in the bargaining unit on strike or locked out and who is working at another location We spoke about that not too long ago. And D, any volunteer, student, member of the public, or family member of the employer. Many witnesses expressed concerns about the law not being clear enough, and they said that there were many possible loopholes. So this NDP amendment seeks to fix that.
Did you have your hand up?
Yeah, I had circulated a sub-amendment. I think everyone has. Just wanted to make sure that it was circulated.
Mr. Sheen, you have the floor,
On the sub-amendment?
if that's what you wish to do.
Yep, sub-amendment. So the sub-amendment that we proposed is, we heard in testimony before the committee, the union's advocating for the broad ban on replacement workers, and they asked that employers be banned from bringing in other employees to work at the location where the strikes or lockout is taking place. They also said they wanted to close loopholes by banning volunteers and other non-standard replacement workers. We agree with this and that part of it that our colleague has placed forward. And so when employers bring employees from other work locations, it could undermine the prohibition by taking the focus away from the bargaining table. When we found a loophole like using volunteers, people lose faith in the law, and we don't want that. We want Bill C-58 to work, so we agree with that portion. However, there are issues with the way the amendment is written when it comes to location. That's why we're happy to support this amendment with the sub-amendments we have proposed. So on the second part of that, family members are difficult to define, and this would only affect the smallest business. However, we understand why unions have concern about volunteers. That's why banning the use of volunteers, we're also creating an additional check of the system so that there's no ambiguity about who will volunteer and who gets paid. So basically, what we're looking at is removing family member as defined, because we agree with most of it, save and except a family member, such as somebody's wife that would come in during a strike. Most of our workplaces are, under the federally regulated system, are larger, and so I believe that covering most of what the NDP put forward, save and except a family member, that's just the sub-amendment. So we agree with everything, save and except the family member.
Okay, I believe everybody has a copy of Mr. Sheehan's sub-amendment. So now the discussion moves to the sub-amendment of Mr. Sheehan. Monsieur Boularus.
Oui, merci.
Thank you, Chair. I would like to move a friendly sub-amendment. It goes in the same direction as what the NDP proposed, to reformulate how we describe the workplace. Now, I've heard colleagues about their concern about the definition of a family member. We maybe don't need to define the notion of family in the Canada Labour Code because there are so many different family compositions, and that can lead to all sorts of interpretation issues, which we don't want. We want this bill to be clear and effective. For us, it's important to include a definition of volunteer and all other member of the public. I think that we have just taken a step forward in defining those who cannot go to the place of work and engage in work. I think it's an important sub-amendment, and that sub-amendment goes in the same direction as what we, the NDP, are moving.
What was the friendly part of that? Mr. Bowlers, could you give us the friendly part of the sub-amendment so we're clear? What were you amending? It wasn't clear to me, so could you make it clear? I thought you were proposing. Okay, currently on the floor then is the sub-amendment of Mr. Sheehan. Seeing no further discussion, I will call a vote on the sub-amendment of Mr. Sheehan. to NDP 4, right? NDP 4. Clear? Everybody clear? So, Madam Clerk?
Mr. Fragiscaros?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Sheehan?
Yep.
Mr. Van Bynen?
Yes. Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yeas pour 11, 11, nays contre 0, aucun.
The sub-amendment of Mr. Sheen is carried. We will now vote on NDP 4 as amended. Madam Clerk?
Mr. Fragiscaros?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Monsieur Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yep.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yeas pour 11, 11, nays contre 0, aucun.
So NDP Amendment 4 as amended has been carried. We'll now move to Bloc Québécois Amendment number 3. Madame Chabot, you wish to speak to it?
Ben, je nous
Yes. I will talk to you about BQ3, which would amend by deleting section 14.5, which is a list of exceptions. Exceptions to what the goals are. That is, to not have strike breakers in case of strike or lockout. If we were all listening during witness testimony, unions said yes. But we cannot do indirectly what we wish to do directly. Someone gave the metaphor of cheese where there are so many holes, meaning so many exceptions. If there are so many loopholes and exceptions, will we really reach our goals, our intentions? 14.5, with the current wording, allows the continued use of contractors before the notice to bargain is sent. That flies in the face of the goal of the bill, if that truly is our goal. So I encourage the committee to really to remove as many exceptions as possible, exceptions to the rule, because we don't want exceptions to become the norm, in fact. And that is why I wish to remove 94.5. And one witness was very clear in their concern about this clause, because the wording currently means that even before the beginning of bargaining, employers could call on employees of another employer as subcontractors to do the tasks and labor. So if we wish to uphold the intention of the bill, we should, in fact, remove 94.5. We've always been concerned about this in the Bloc Québécois. We support the bill, but we must ensure that it fulfills its objectives.
Mr. Shea?
Yeah. Bill C-58 bans employers from using contractors as replacement workers. It's clear. So we won't be supporting this as this amendment. We just want to make sure the Bill C-58 is clear and doesn't, lead to any more issues that would be going down the pipe. And we thought hard on this one, and we can't support it.
Seeing no. Madame Chabot?
Je pense qu'il peut poser problème.
Well, I think that can be problematic, in fact. This section refers to continuation of service, continuity of service. If we want to be clear, well, there was an agreement, but you say that there can be continuity of service if before the date of the notice to bargain is given, an employer or someone acting on behalf of the employer used the service of someone mentioned in Section 4B. So we're saying, well, we don't want replacement workers, but if they start before the notice to bargain, then it's fine, they can continue. Well, this gives employers all the means and advantages that they need to skirt the legislation.
Thank you. I will, Madam Clerk, we are voting on Bloc Québécois Amendment 3.
Mr. Frage-Descaros?
No.
Mr. Long?
No.
Mr. Collins?
No.
Monsieur Sheehan?
Nope.
Mr. Van Bynen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Miss Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yes pour 2, 2, nays contre 9-9.
Bloc Québécois 3 has been defeated. We'll move to NDP 5. Monsieur Boulris?
Merci,
Comment?
Monsieur le Président.
Thank you, Chair. NDP 5 is about something that is rather contentious, and we feel it warrants clarification. That is union strategies that can be used for partial or rotating strikes. This has been seen in several sections. The progression of pressure tactics is used by unions. So rather than immediately calling a general, full, unlimited strike, unions progress gradually. But to me and to many unions, it's not clear whether replacement workers are allowed in the case of partial or rotating strikes. And that's why the NDP is moving this motion today, or this amendment. That is, we want the principles of the bill to also apply to rotating and partial strikes. We want people to be prevented from going to the place of work in the case of rotating or partial strikes, or if the place of work changes. Thank you, Mr. Chair.
Discussion?
We can't support this amendment because we feel it would take away the tools from the unions. Just in particular with this amendment, if a union wanted to do a rotating strike with 5% of its workforce that walked the picket line while the other 95% worked, wouldn't be possible. So we're worried about the unintended consequences of the union wishing to withdraw some of their services on a particular day or what have you. So that's it. We won't be doing the
Thank you. Seeing no further discussion, Madam Clerk, record a vote on NDP 5. We're voting on NDP 5.
Mr. Frage-Descaros?
No.
Mr. Long?
No.
Mr. Collins? Monsieur Sheehan?
No.
Mr. Van Bynen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Miss Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yes pour 2, nays contre 9-9.
NDP 5 has been defeated. We'll move to NDP 6. Monsieur Boulris?
Merci, Monsieur le Président. Vous allez voir que les deux prochains...
Thank you, Chair. The next two NDP amendments are rather simple, because earlier we added C and D at, I forget which section, 94, yes, thank you, for employees at another place of work. And we've also addressed volunteers and any other member of the public. So these are amendments because it's not just from A to B, but from A to D, because we have added C and D in an amendment that has carried. So that's why we suggest from A to D. And you will see this in NDP 7.
Seeing no discussion on NDP 6, we're voting on NDP 6. Monsieur Bellers?
Il y a un élément supplémentaire.
There's one more element that I'd like to add. This also aims to give unions the ability to be the first to appeal when it comes to work carried out at the workplace in clauses already included in the bill. So the union would be the first called so that the bargaining unit can do that work if that is what the local unit wants. So they would be the first to be called. They'd be the first to be able to go to the workplace if they wish to do so.
Mr. Seebeck?
I just want to understand what the full effect of this is. Is it just adding C and D because of a previous amendment, or is it more than that? And if it's more than that, what is it? And I'd love to hear from our witnesses on that, or the legislative clerks.
Sure, direct your questions where you choose.
Yeah.
Departmental staff, and then if that's not clear, we'll go further.
Okay. So the effect of the addition of this new C would be essentially to require the employer to, before resorting to replacement workers who would otherwise be illegal under the Act, to deal with some of these exceptional circumstances like threat to life, health, safety, et cetera. It would require them to give union members the opportunity to do that work during a strike or lockout before resorting to those otherwise illegal replacement workers. So it's adding a step essentially before the employer can use the exception listed here. Happy to elaborate on that. I don't know if that's clear.
Okay, Mr. Seebeck? Okay. Seeing no further discussion, I'm going to call a recorded vote on NDP 6.
Mr. Fragiscados?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Monsieur Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gregg?
Yes.
Mr. Seeback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yeas pour 11-11, nays contre 0, aucun.
NDP 6 has carried. We'll move to NDP 7. Monsieur Bouleris?
C'est la même chose. Yeah. Sur NPD 7,
NDP 7. We wish to amend A to D.
oui, je pense qu'il n'est plus nécessaire NPD 7.
In fact, NDP 7 is no longer necessary because we have NDP 6.
Okay.
Thank you, Mr. Chair. Oui, en effet, c'est plus nécessaire, c'est déjà couvert.
It's true that it's no longer necessary as it is covered by the previous amendment.
Do we need to vote on it?
No, no.
We move to Bloc Québécois 4. Okay, so that one is redundant. We don't have to vote on it.
Mr. Chair, would it be possible just a brief break? We've had a lot of changes to this. We're getting close, and we want to.
Good idea. And we'll see if we can track down where the coffee went. We'll suspend for 3 minutes, fine? 3? Okay, stretching it, 5, spend for 5. so we will resume. And we are now at Bloc Québécois 4. Madame Chabot. Madame Chabot.
Ah oui. Sorry. Bien,
Well, there will be no surprises here. There weren't any surprises earlier, though, either. The goal of our amendment is to add to the bill an investigation process. This is similar to what we have in our Quebec legislation. Unions explained to us just how important this is to them. They explained that it's important to be able to investigate. In the case of a strike or a lockout, unions are totally unable to verify whether an employer is or is not in contravention. So an investigation process would give unions that ability. So if it's someone from the CIRB, they would be able to, accompanied by the union, investigate to determine whether the act is being followed. This would be with legal experts. This amendment is not exactly fully copy-pasted from the Quebec version, but this amendment is very similar and it would be helpful for the Canada Labour Code.
Je pense que ça pourrait être un enrichissement.
I feel that this could significantly improve our legislation.
Discussion? Seeing none, I will go to a recorded vote on the amendment of Madame Chabot as listed BQ4.
Mr. Fargas-Gatos?
No.
Mr. Long?
No.
Mr. Collins? Monsieur Sheehan?
No.
Mr. Binen?
No.
Mrs. Gray?
No.
Mr. Seaback?
No.
Ms. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yes pour 2, nays contre 9.
Bloc Québécois 4 has been defeated. That concludes Clause 9. Shall Clause 9 carry as amended? See an agreement? Clause 9 is carried as amended. We'll go to Clause 10, and we have NDP 8. Monsieur Boulris?
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. This amendment is to include elements C and D, which have already been voted on. Thank you.
Discussion? Seeing none, recorded vote on NDP 8.
Mr. Fargas-Gatos?
Yes.
Mr. Long?
Yes.
Mr. Collins? Monsieur Sheehan? Mr. Van Binen?
Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Oui.
Madame Chabot?
Oui.
Monsieur Boulris?
Oui.
Yes pour 11, 11, nays contre 0, aucun.
NDP 8 is carried. Shall Clause 10 carry as amended? Seeing none consent, Clause 10 is carried. Shall Clause 11 carry? Seeing agreement, Clause 11 is carried. Shall Clause 12 carry? Nodding, Clause 12 is carried. Shall Clause 13 carry? Seeing agreement, Clause 13 is carried. Shall Clause 14 carry? Seeing agreement, Clause 14 is carried. The new Clause 14.1 has a Bloc Québécois 4.1. Madame Chabot?
Merci, Monsieur le Président.
Thank you, Chair. During witness testimony, what we heard was shock. They were shocked when this bill was tabled by the government. They were shocked that employees of the public service would not be covered by the same provisions. So there were some very legitimate questions being asked. They were wondering, for private businesses under federal jurisdiction or federally regulated, they were wondering why the federal government is not also, as an employer, protecting its employees, that is, employees of the federal public service. This amendment would ensure that the provisions of Part 1 of the Canada Labour Code relating to replacement workers would apply, with necessary modifications, of course, to the public service and all persons employed in it. So the principle and the goal of this would be to ensure that our public service employees are protected by the same provisions.
Madame Chabot, as chair, must rule on admissibility or inadmissibility of amendments. This amendment seeks to add a new section 4.1 to the Federal Public Sector Labor Relations Act, which is not amended by the bill. As House of Commons Procedure and Practice, 3rd edition states on page 771, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act, unless the latter is specifically amended by a clause of the bill. Since the Federal Public Sector Labor Relations Act is not being amended by Bill C-58, it is therefore the opinion of the chair that the amendment is inadmissible. My ruling. Good? One can challenge. Madame Chabot, no discussion. You can challenge my ruling only.
J'ai beaucoup de respect, Monsieur le Président.
I respect your decision, Mr. Chair. As for eligibility, it's understandable. These are different acts. But my goal is not to immediately amend the Public Service Act, but I wish to ensure that we uphold the principle of covering and protecting public servants. I'd like the legislation to be modified or amended to include the federal public service, and thus, Mr. Chair, with all the respect I have for you, I would like to challenge.
On to clause 15. Oh, sorry, I did. Oh, fine. Okay, sorry. My mistake, Madame. So you've heard Madame Chabot has challenged my ruling, which takes us to a direct vote. Committee members, you can uphold the ruling of the chair, or you can agree with Madame Chabot. It is left to the committee members to decide. So the vote, recorded vote, is on the ruling of the chair.
So members, the question is, shall the chair's decision be sustained? So that means that if you vote in the affirmative, you're voting to support the chair's ruling. And if you vote against, you're voting, well, if you vote in the negative, you're voting against the chair's ruling. Mr. Fragiscados?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Sheehan?
Yes.
Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Non.
Monsieur Boulris?
Par cohérence, oui.
Yeas pour 10, nays contre 1.
The chair's ruling was upheld. We'll move to clause 15. Shall clause 15 carry? Carried. Shall clause 16 carry? Seeing no discussion, clause 16 is carried. On clause 17, we have NDP 9. Monsieur Boulris?
Monsieur le Président, NPD.
Mr. Chair, NDP 9 is no longer relevant given the amendment that we recently made to Article 7.
Okay, sorry, I was distracted. Oh, he's not moving it, okay. So he's withdrawing it?
No, just not moving it.
He just, okay. Clause 17 carry? See an agreement? Clause 17. Did somebody say no?
C'est l'article 17 qu'on est rendu, Monsieur le Président, et pas 18, parce que moi, j'aurais une question à poser sur l'article 17 avant de voter sur l'article 17.
Point of order, Mr. Chair.
J'aurais une question à poser à nos témoins.
No.
I have a question for the witnesses, please, Chair.
So could you repeat that?
Qu'est-ce-
Could you, Madame Chabot, could you,
Avant, oui, je comprends.
Yes, I understand. Is everything working? Excellent. So, if I understand correctly, we will no longer have this NDP amendment, but we do have to vote on Clause 17. And I have a question about Clause 17, about the transitory measures of Clause 17. It says clearly in subsection 3, I won't read them all aloud, all the subsections, but essentially 94.4 to 8 and whatnot will apply as of the date of coming into force. So that's the transitional provisions. It will apply to all strike or lockouts ongoing at that date. Have I understood correctly? My understanding is that at the moment, at the date when the bill comes into force, and we will decide on that later, but that as soon as the legislation comes into force, let's say it's tomorrow, it won't be tomorrow, but hypothetically, if it were tomorrow that it came into force and there were strikes or lockouts ongoing that had already started, that were going on tomorrow, thus the provisions here would apply to any ongoing strikes and lockouts. So here's my question. Will this apply as soon as the bill comes into force?
Oui, c'est bien ça.
Yes, that is accurate.
The law, the provisions related to the ban on replacement workers will apply as of the day the bill comes into force and will apply if there's an ongoing strike or lockout as of that day. So in practice, if that means an employer is using replacement workers that would be prohibited by the ban when the bill comes into force, then as of the day that it comes into force, they would no longer be able to continue doing so.
De la date d'entrée en vigueur. Fait qu'on rétroagit pas. La mesure
So the transitional measure will only apply if there are strikes or lockouts which are ongoing at the time the bill comes into force. Well, I'll continue, Mr. Chair. I think that, unfortunately, workers who are currently on strike, for instance, those at the Port of Quebec replaced by replacement workers, or the situation at Videotron, I think it's clear to them that having the bill come into force earlier will help other labor disputes, but will not help them with their situations. Thank you.
okay, seeing no further discussion? No further discussion. We're on Clause 17. Shall Clause 17 carry? See an agreement? Clause 17 is carried. We're now with Clause 18. Madame Chabot, you have an Amendment 5.
de l'amendement BQ5.
Yes, BQ5. Well, it won't come as a surprise to you because from the very beginning of discussions on this legislation, the government with the NDP, they made it such that it would come into effect 18 months after royal assent. That seems excessively long in our view. It's especially long compared to the goal that we have. When the government tables legislation such that when it comes into force after royal assent, that it can be effective. We want it to be effective as soon as possible, right after royal assent. So why wait 18 months? That seems truly excessively long. So picture it. First, we have to get to royal assent. Ideally, that would be in about 6 months. Then 18 months after that, so 24 months from now, it would finally come into effect. So that means 24 months at least where the totally ineffective and not strong enough provisions of the Canada Labour Code will be in effect for workers. 24 months. This legislation is historic. It will be historic as soon as it comes into effect. So here's my amendment. My amendment would be for it to come into force on the day after royal assent. 1 day after royal assent rather than 18 months after royal assent. Furthermore, the explanations are not clear. With all due respect, Mr. Chair, how could my NDP colleagues have supported such a long wait time? We want the support of other parties. Those who say they stand for workers' rights should support this amendment so that the legislation can come into effect as soon as possible. So I urge all colleagues to support this block amendment. This is the very least that we could do, especially given the fact that this bill is sturdy. We feel, though, that some exceptions should have been struck from the legislation. But we need to be ambitious. It's a good bill, so let's have it come into effect. The government and they've often defended the needs of the Canada Industrial Relations Board. And the board, they talk to us about resources here in committee. And those resources are insufficient, in fact, but it's a government board and the government has goals and ambitions. They should ensure that the legislation comes into effect with the necessary resources for success. So there you have it. Our amendment is that this act come into force on the day after the day on which it receives royal assent.
But if BQ5 is adopted, NDP 10 cannot be moved because it is a conflict. So any further discussion on BQ5? Not seeing any. I will call a vote on BQ5.
Mr. Fargas-Gados?
No.
Mr. Long?
No.
Mr. Collins?
No.
Mr. Sheehan?
No.
Mr. Van Bynen? Mrs. Gray?
No.
Mr. Seaback?
No.
Ms. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
Oui.
Monsieur Boulris?
Non.
BQ5 is defeated. That allows us to move to NDP 10. Monsieur Belarus on NDP 10. And just remember, the lights that are flashing is simply the opening of the House.
Merci, Monsieur le Président.
Thank you, Chair. We heard unions and witnesses who were very worried about these 18 months. It's too long, indeed. We want to ensure that people can benefit from this anti-scab legislation as soon as possible. I would have had this come into effect years ago. But we have to do things well. The director of the Canada Industrial Relations Board did tell us that she needs some time for hiring and training. Through Amendment NDP 10, There is some progress. Witnesses told us that 18 months is too long, that it needed to be shortened, but we also need to take into account the needs on the ground. We want this legislation to come into effect in a realistic, effective, and efficient manner. So we should cut 6 months off that time. We should go from 18 months to 12 months, and that is the gist of NDP 10.
Question on NDP 10. Seeing Madame Chabot on NDP 10.
Monsieur le Président,
Mr. Chair, I disagree. I cannot support this amendment. I'm not saying that the CIRB's points are not valid, but that's a matter of means and resources. What we need is to protect workers and give them justice and fairness as soon as possible. The Bloc feels that nothing justifies such a long wait. Workers did not come to committee asking us to shorten the wait time from 18 to 12 months or to 9 months. If you go and look at witness testimony and reread it, you might find that one witness requested a 12-month delay. But for unions on the ground who are experiencing the harmful effects of the current situation in Canada, well, what they asked us was to shorten the wait time. Shorten the delay, because nothing justifies such a long delay, be it 18 months or 12. 12 months is too long. So I strongly oppose this amendment. An overwhelming majority of workers and witnesses said that such a long delay is unjustified. We should not wait so long, according to them, to give workers their rights. In the bargaining for a labor contract, in fact, bargaining is always the best resolution in the case of a lockout or a strike. And I do agree with my colleague in the sense that this should have been done in 1997. The Bloc Québécois has been calling for this since 1990. And my colleague, my NDP colleague, said this should have been done 25 years ago. But finally, we do have this legislation. It is hailed and welcomed by all. But we do need it to come into effect as soon as possible. Thank you, Mr. Chair.
Further discussion on NDP 10. Recorded vote on NDP 10.
Mr. Fergus-Carros?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Sheehan?
Oui.
Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Oui.
Madame Chabot?
non.
Monsieur Boulris?
Oui.
Yes pour 10, 10 nays contre 1, 1.
NDP 10 has been carried. Shall clause 18 carry as amended? Seeing no dissent, clause 18 is carried as amended. That concludes the clause by clause of the bill. Shall the title carry? The title is carried. Shall the bill as amended carry? The bill as amended is carried. Shall the chair report the bill as amended to the House? In agreement? That's it. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Good? Okay, thank you. I just have to clarify what's going on with the lights. It's the committee's choice. We concluded the bill as the committee. I have a couple of small items. Oh, no. Okay. Is it the wish of the committee to continue to our time slot? Yes. Okay. We need unanimity. Okay. Thank you. What? Did I miss something?
No, never mind.
You guys fine?
Yep.
Good? Okay, the bill is fine. Okay, I have an item, but I'll go to Ms. Gray, who asked for the floor.
Thank you, Mr. Mr. Chair, we have our meeting on Monday where we have ministers attending. And given the recent developments that we've seen with the Minister of Employment, Workforce Development and Official Languages, I would like to move the following motion. Given recent developments, the Minister of Employment, Workforce Development and Official Languages of Canada extend his appearance on Monday, May 6, 2024 by an hour, so he appear for a total of 2 hours.
Sorry, my apologies, Ms. Gray. I'm going to get you to repeat that. I was being distracted. Ms. Gray?
I would like to move the following motion, Mr. Chair.
Okay.
Given recent developments, the Minister of Employment, Workforce Development and Official Languages of Canada extend his appearance on Monday, May 6, 2024 by an hour, so he appear for a total of 2 hours. And the reason for this is there have been recent headlines over the last couple of days, very concerning situation involving the Minister of Employment, Workforce Development and Official Languages as reported in the media. And the minister should be answering some questions. We also have a lot to cover in his portfolio, and so we believe that it is not unreasonable to extend the time that he's here at committee by an hour to be here for 2 hours instead of only 1 hour.
Thank you, Ms. Gray. I'm going to allow the motion to stand, I will allow it to proceed to discussion. Ms. Gray, has you all heard the motion? Comment? Discussion? Pardon? Recorded vote? Okay, see no further discussion. Ms. Gray's motion is clear. I have agreed that it is in order. Madam Clerk, we'll go to recorded vote on the motion of Ms. Gray.
Mr. Fragascaros?
No.
Mr. Long?
No.
Mr. Collins?
No.
Mr. Sheehan? No. Mr. Van Bynen?
No.
Mrs. Gray?
Yes.
Mr. Seaback?
Yes.
Ms. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
No.
Monsieur Boulris?
Non.
So yeas pour 4-4, nays contre 7-7.
So the committee members, so just a couple of items. We do receive at last month, we have 4 applications, submissions for the Centennial Flame. So we will not be extending the timeline. I need some direction. Bill C-322, Private Members Bill. I need a deadline for the witness list. We agreed 1 witness per each of the parties. So what deadline does the committee with? Suggested date, I believe it was a Friday, May the 10th. Friday, May the 10th, okay, for you to get your 1 name into the clerk for the witness on C-322. Good. Also in relation to C-322, the deadline I'm suggesting for submitting amendments ahead of the clause-by-clause meeting scheduled on Thursday, May the 30th. A suggested date could perhaps be at noon on Monday, May the 27th. Is that agreeable? Monday, May the 27th for amendments to be submitted for clause C-32 because we are doing clause by clause on May the 30th. So we have agreement on that date. Good. Oh, yes, okay. Mr. Coteau will be tabling the committee's report on artificial intelligence on Tuesday, May the 7th during routine proceedings. A draft press release was prepared and circulated. Is it wishes of the committee to circulate the press release? See agreement? With that, the next meeting will be on Monday, May the 6th. Is it the wish of the committee to adjourn? Committee is adjourned. Thank you, committee members.